Hello everyone, I am Bahar Tunçay and we will summarize the first chapter of our book, Business Law. In this chapter, we are going to discuss first the concept business law, then the development of this concept, and later the need for business law. Next, the sources of Turkish law, the concept of person and capacity of persons will be discussed. Okay, now, before defining the concept business law, we need to clarify what we mean by the term business. Business is mostly defined in two different ways. In the first one, it refers to a person's regular occupation, profession, or trade. And in the second definition, it refers to all the commercial activities that someone performs. And business law is a branch of law dealing with all the legal problems caused by business activities. Thus, in this book, the word business will mainly be used to refer to a commercial activity or work done to earn money. In other words, we are going to take the second definition into account. Business law may first of all be relevant to starting, managing, and transferring a business. It is also relevant to issues such as selling and buying, thus to contracts and consumer protection in return. Moreover, labor law and commercial enterprise are very important topics as well, because the rights and duties of merchants should be dealt with care. In running a business, it's also important to know about the fiscal system, taxation, and the court structure. By being familiar with the court structure, a person will know where, how, what, and when to sue. There are also new alternative dispute resolution methods such as either voluntary or compulsory mediation or national or international arbitration. Let's move on to the development of business law. The origins of business law may be found in the law merchant, and today there are two highly dominant legal systems in the world. The first one is Anglo-American law system, and the second one is the continental law system. Anglo-American law system is derived from the common law in England. And in this system, the previous judgments bind and form the main source of law. On the other hand, continental law system has its origins in Roman law, and it keeps the legislation as the foremost source of law. Turkey is a continental law country. Business law first completed its development in Anglo-American law, and then it spread to the continental law countries. The need for business law arises especially because it regulates sales of goods, carriage of goods, consumer credit agreements, and labor relations. Let's look at the sources of Turkish law. Article 1 of the Turkish Civil Code enables us to understand the sources of Turkish law. According to this article, the sources of law can be classified as primary sources and secondary sources. Primary sources involve written laws, customary law, the judge as a lawmaker, and secondary sources involve the doctrine and court decisions. Written laws are the constitutions, codes and statuses, international treaty regulations, and bylaws. When the written laws, especially in the private law, are silent, the judge should try to find an applicable customary law principle. If it is also silent, and if the judge finds that there is a real legal gap, they need to act as a lawmaker and lay down a legal rule. The judge may be guided by the legal doctrine and previous court decisions, but these two sources are not binding. Let's go on with the concept of person. A person is a being that is recognized by law as a subject of rights and obligations. There are two types of persons, namely real persons and legal persons. Real persons are the human beings, and every human being is considered as a person in the modern legal systems. On the other hand, a legal person refers to a non-human entity that is treated as a person for limited legal purposes. In order to be considered as a legal person, the law system has to recognize it as a person. So, what are the requirements for being legal entities? For example, they need to be established for a specific purpose. Besides, they have to be associated, organized, or incorporated independently of the persons that form the legal entity concerned. Plus, the law should recognize the independence of the legal person. As their establishment formalities, there are three different ways that the legal entities are subjected to. The first one is by way of registration in the relevant registry. The second one is by way of permission from the relevant authority. And in the last one, there is no specific requirement for the establishment. Here are some examples for private law legal persons, such as general partnership, limited partnership, and so on, which fall into the category of profit-making ones. And associations and foundations falling into the category of non-profit-making ones. When we look at the chart, we can also see that there are three subcategories of public law legal persons. The first one is administrative institutions, and state, city, etc. fall into this subcategory. Second one is public enterprises, such as social public institutions, such as social security institutions, cultural public institutions like TRT, and state-owned economic enterprises such as associations. Every real person has the capacity to have rights and duties, and capacity to have rights and duties is a passive capacity. In other words, being a real person is the only requirement for this capacity. Capacity to act, on the other hand, is an active capacity. A person who has the capacity to act has the capacity to acquire rights and incur obligations through their own actions. In other words, to have full capacity, there are three requirements: the concept of majority, the capacity to make fair judgments, and not to be interdicted. For having full capacity, the person has to fulfill all the three requirements and may enter into any kind of transaction. A person with limited capacity has also the three requirements, but his or her capacity is limited for certain legal transactions. Persons of limited incapacity are the persons having discretion, who are able to make fair judgments, but either are not full age or are interdicted. There is one more category here, the ones who do not have discretion, and as persons with full incapacity. And this is the end of the presentation. Hope it will be helpful. Thanks for listening.